Today's most relevant topic is how to draft an EOT claim under the force majeure clause for a force majeure. So many contractors assume that a random force majeure event will automatically gives the position or the strategy for the contractor to go for an EOT, which is totally false. That is why this video is being made, and we'll break it down how it is possible to make it or to draft an EOT claim under force majeure. So start with the contract, not the event. So most of the project professionals or contract professionals will read the contract only when such event occurs, because we always handle the contract retrospectively, which is not good. You have to be proactive by understanding the contract clauses before the events occur. But still, that's fine. You're not at the contract, the measure, force measure has been occurred. So you're reading the contract. So be careful on what is the definition of the force majeure and what is the definition of the exceptional events. So notice requirements, what are the timelines and the formats required, EOT entitlement class, cost entitlement class, if you duty to mitigate, engineers or the employees determination mechanism. So you go the class specific interpretation has to be the first step of the drafting EOT. Establish that the event qualifies as a force majeure. Most employers reject saying that no, this is not a force majeure, because not any government authority is going to declare this as a force majeure, or any authorities doesn't have capacity to declare it as a force majeure. Two parties has entered into a contract. One party is declaring it as force majeure. If the other party that stating is force majeure, then that we execute. So how to qualify this as a force majeure? If the word is directly mentioned inside the contract, for example, war, conflicts, pandemic, epidemics, so that itself qualifies that as a force majeure. So you have to prove. Otherwise, you have to prove that it is beyond the control of the affected party, unforeseeable at the time of the signing of the contract, unavoidable despite reasonable efforts taken by the contractor, and not attributable to either party. For example, a government imposed lockdown during COVID-19, that may qualify as a force majeure. However, shortage of the labor due to poor planning of the contractor himself will not qualify as a force majeure. The risk areas, employers often argue that the event was foreseeable or manageable. This is where contemporary records become critical. You'll see that later. Strict compliance with notice provisions. See, force majeure clauses and the claims character are strictly time-bound. So you have to follow the notice requirements. Initial notice within X days from the date of aware by the contractor or the employer. Follow detailed claims with 4 days. For example, if you are submitting the notice in 14 days, and after 42 days or 20 days, depends on the contract, you have to submit the detailed claim. Claim is nothing but it has what is the impact of the time and the cost inside the contract. What is the best practice? Issue notice immediately upon the occurrence. This most of the guys will do, even though it is a force majeure or not. Reference the exact contractual clauses. It might be multiple clauses. Clearly state that EOT is being pursued. Avoid vague for information only notices. Strict compliance with the notice provisions. Continuation. So this is an example for a structure of notice. We have seen so many videos of how a force majeure notice has to be made. It's just a brief of that. So describe the event, the date of occurrence, affected activities, because you will not be doing critical path analysis and you don't know that whether these are critical activities, but you can write the list of activities that gets affected. Statement of potential delay, reservation of rights. This is more important. The strategic insight is failure to comply with the notice provisions can bar the claim entirely, especially in strict contracts. Under many EPC contracts, notice is a condition. Demonstrate the causation, the core of the claim. So what you have to prove is that there is a force majeure event that impacted the critical activities, and that delay extended the project completion date. So what is not sufficient is like vague statement like the project was delayed due to Middle East war conflicts. That is vague. So how it should be written? It should be very specific linkage between the event and the critical path activities. So what is the right approach? Identify the affected critical activities in the program, demonstrate how the event disrupted the entire project, show that these activities fall on the critical path. So the important tools you have to use is you should have a baseline program, you should have an updated program, you should have a critical path analysis, and you should be able to make a recovery schedule or a lookout schedule. Carry out delay analysis. Method selection matters always. This is very, very interesting as well as a critical area because many delay analysis gets rejected or EOT claims rejected because of the wrong selection of the methodologies. The choice of delay analysis methodology significantly impacts the credibility. What are the recommended methods? Either we go for a time impact analysis, preferred in live projects, or we go for a window analysis for retrospective claims or ABM analysis. This is just a recommendation. You can follow the international standards such as SCL at AACE that based on the input availability and time availability and the complexity of the project, you can select the projects. For example, time impact analysis. So you have to insert the force majeure event into the approved program. Model the delay impact. Demonstrate the resulting shift in completion. Time impact analysis, it's more important to know that you will be doing this on the updated schedule, not on the baseline schedule. So strategic insight is avoid simplicity net delay statements because decision makers expect methodological and transparent analysis aligned with protocols such as SCL, delay and results. Substantiate with contemporary. So delay analysis is not standalone analysis. It is backed up with facts. The facts are backed up by the contemporary records. Every date you are using delay analysis is going to be have a backup either from the daily progress report or site diaries, correspondence with authorities, might be email or letters, instructions from the employers or engineers, which will result in variations, labors and equipment logs, procurement records, minutes of meetings, and so on. You may also have photographs, video, anything. Example, if claiming delay due to supply chain disruption, what all should be maintained is that provide supplier correspondent. Supplier himself should say that we have been hit by force majeure and we are not able to supply the materials. Shipping delays. You should get letters from the shippers and port closure notices. This you can take. These are public domains, available in public domains. You can take them. So what is the strategic insight? Is claims are one on records, not on arguments. Address concurrency. Employees' primary difference. Force majeure delay overlaps with contractors' own delay. This is the usual argument from the employer. And he may be right also. So if they are coming up with an concurrency, and it has to be because you are not eligible for the cost completely, even though it covers any other under any other classes or requirements. So EOT may still be granted. Cost entitlement is usually denied. The best practice is separate the delay periods clearly, demonstrate that the force majeure affected critical path independently. If concurrent, establish the dominancy of the demonstrate mitigation efforts. So mitigation efforts are mandatory for a contractor under the obligations of the contract. So what are the things a contractor attempted? Whether you attempted for alternative sourcing attempts, source allocations, acceleration measures. Acceleration is not a mandatory requirement, but if feasible, it should be done in the contract. Coordination with the stakeholders. Example, if the material supply was disrupted, evidence of alternate supplier exploration, whether you try to get the material from the other suppliers locally or from any part that has not been affected. Okay. Logistic replanning. If a logistic route has been blocked, if you have an issue with the seaport or sea issues, whether you tried for an airlift or by a road, So that has to be discussed. Passive contractor weakens its own claim. Passive contractor in the sense that is not proactive or mitigating the issues. Quantify the extension of time. So the client must clearly state what is the total delay period claimed, breakdown by the events, multiple events, impact on the key milestones, avoid lump sum delay claims without explanations. And what should be preferred is that, again, event, activity, delay, supporting events. Structure of the claim document professionally. So how it should be well structured is that it should have an executive summary, contractual basis for the entitlement, description of the force majeure event, chronology of the events, notices issued, very important area. What is the delay analysis? What is the impact on completion? What are the mitigations? EOT entitlements, supporting documents, annexures. So decision makers often read only the first few pages. So that's why executive summary is very important, that it gives the entire background of the story, and that should be compelling and precise. Address cost entitlement separately. So under many contracts, EOD is granted, cost is not automatically granted. Key consideration is, does the contract allow cost for force majeure? Usually contracts doesn't allow for force majeure under very few areas. What if there is physical damages on the buildings under force majeure such as war, and that has to be compensated. So those things are. So example, typical question is time yes, cost no. Best practice is do not mix cost and time. This is not only for force majeure EOT claim. This is for any EOT claim you go. You first question yourself on the time and then derive the cost, because cost is dependent on the time coordinate. So you position yourself and get the approval for the time coordinates and then go with the cost coordinate. Align with the engineers and employees determination process. So each contract has a separate determination process. So it will have an engineer's review and an employee's approval. So make the engineer's determination easy and defensible, because you know that what are the requirements under the engineer's determinations, and that has to be provided as a contemporary. So present clear logic, avoid aggressive or emotional language, always anticipate counter arguments. You must anticipate counter arguments and make ready your responses for that. The common mistakes that kill EOT claims: late or complaint notices that is not entertained in any of the contracts. Generic statements without linkage to the cost issues. No critical path linkage, weak or missing delay analysis, lack of records, ignoring the concurrency, no mitigation evidences, brief of claims. So strategic position and think beyond the EOT claim is not just a technical submission, it's a commercial and legal strategy. So advanced consideration is protecting against liquidated damages, preserving the entitlements for prolongation costs, positioning for dispute resolution boards or dispute adjudication boards, maintaining working relationship with. There is another ultimate positioning for the client. Have a single focus on the completion of the project and delivery of the project at any cost. So real world insight is the strongest claims are those prepared from day one of the event, not after the occurrence of the or dispute or the completion of the project, which is usually being done. So we have come to the end. So in very high value projects, the difference between a rejected claim and a successful one is rarely the event, because one contractor will not get the EOT for the same force majeure. The other contractor in the same region will get a force majeure claim for the same. So it is a discipline of how the claim is firm. Thanks for watching this video. If you are interested to learn more, please look into our Master Diploma courses on international standards. And if you have any other consulting business queries, please contact on the below. Thanks for watching. Take care. Bye.